Aloha and welcome to Ehana Kako. We're a weekly program on the ThinkTech Hawaii Broadcast Network. I'm Keli'i Akina, president of the Grassroot Institute. The venerable building I'm standing in front of is well known throughout Hawaii as our state capitol. But what goes on behind closed doors? Did you know that we have some of the finest laws in the nation allowing journalists and citizens to look in and see what takes place in government by accessing records and so forth? But we need people who know how to do that and get the job done when things aren't working as well as they should. And today it's my privilege to talk to one of those people. He's the executive director of the Civil Beat Law Center for Public Interest. And I always mess that up because it's longer than Civil Beat. Although it uses the name of a well-known publication here in Hawaii, it's actually an independent organization that does work with them and many other organizations in order to serve the public interest. Brian Black has had a long career in law and now is in public interest law, and I'd like to welcome to our program today. Brian, welcome. Aloha to you.
Thanks for having me, Keli'i.
Well, you know, I enjoy our conversations about keeping the spotlight on government, and you're hard at work because there's a lot of work to do in this state.
Yes, there is much to do. That's right.
Tell me a little bit about your organization. What's the correct name of the Civil Beat Law Center?
So it's the Civil Beat Law Center for the Public Interest. It's an independent organization that's set up to help the media and the public with access to public records, open meetings, courtroom access.
Well, it shares the name Civil Beat with a publication, but it's a different group, isn't it?
Yeah, it's completely independent of Civil Beat the publication. It's Civil Beat is a brand that Piero Midyar has identified to help folks identify those resources that are available to really allow for investigative information, to really delve into access to information that may not be accessible just from the government in what it gives out on its own.
In other words, you help people to get that information that the public has a right to know,
right,
but isn't always easy to get. We're going to talk a little bit more about that, but how did you get into this line of work? It's public interest law, but wouldn't you be making a lot more money just suing people in corporate law?
Sure, and I did that for a while, but
you did, okay. Yeah. Good for you.
Yeah, well, I don't know, but no, it's a completely different line of sort of legal inquiry, typically from what you see with folks who practice personal injury law or folks that draft contracts or other areas.
Well, who do you represent in public interest law? How do you get a client and then take their interests to court?
So typically what happens is someone will just call me up and they'll ask, okay, well, or they'll email me and they'll ask, I'm having difficulty getting access to this information. And I'll give them advice. And as we go through the process of me advising them and then them going back to the agency or to the board and trying to get more information, if it gets to a point where they need to either take it to OIP, which is the Office of Information Practices, and ask that agency to help them out, or if they are looking to go to litigation, then I'll do an analysis to say, is this something that's in the overall public's interest, or is this something that's more particular to this individual or this organization, and it doesn't go beyond this particular request.
So you're interested in cases that are going to serve the large body of the public, not just somebody's need to know a particular piece of information.
Right.
So that's why it's called public interest.
Yeah, and there's a typical name for that would be impact litigation,
okay.
Things that has a strong impact on the entire community.
Well, why is it necessary for us to be able to get this information? I know that may be a very, very obvious question, but we have a government, we have the different branches of government, we have agencies in the government, and presumably they're working around the clock to do what they do right. for society. Why do we need to have the capacity to go and take these agencies or these operatives to court and say, you've got to give us this information?
I think it's founded on the principle that you need government accountability.
Accountability.
And that's, you could get that if you trust your government and they are always honest. And they could be in some contexts. And there are definitely some agencies that are honest and that are always willing to share information. And this is not to say that ones that don't are being dishonest. It's just that the information that the government decides to share is not necessarily the whole story.
So there are agencies that answer Brian Black's calls and agencies that don't. But seriously, you're talking about maintaining checks and balances. And,
Right.
and isn't it typically the case from the civics lesson that we think of checks and balances as being between the different branches of government, the executive, the legislative, and the judiciary? But what you're talking about is another agency altogether, the public, and you represent the public in this process of holding government accountable. How crucial is it that members of the public, or civic organizations or individuals, how crucial is it that they be on the vanguard watching government?
I think state policy recognizes that the public serves an important role here in terms of making sure that there's accountability. And so our state does not leave it to the government to always share all the information. It's up to the public to really follow up and to push and to figure out what the story is.
You know, this is a little known responsibility.
Sure.
I don't know how many people out there in the general public walk around and think it's my responsibility to hold my government accountable. I think that a lot of times people are thinking, I want the government to give me benefits. I want to choose the leaders whom I will entrust with the work of doing government, and then that's about it. And you know, in this state, we have one of the lowest voter turnouts in the country. So I would think that you're involved in an industry that a lot of people are just not aware of or care, and I don't say that in any negative way, but just have much care for or in.
I think a lot of people, as it's developed, have sort of left this role to the media in many respects, and so they see the media as being the potential for that watchdog. And you know, there are other organizations that try to do it, but the media, by making requests and pushing these issues and getting information out there, are serving a pretty critical role in terms of making sure that the public is aware of what's going on.
Now, the need to have watchdogs, the need to be able to go in and get the information in an aggressive legal fashion, presupposes that there's a tendency when people aren't watched to do whatever they want to do without the scrutiny of the public. You're familiar with Hawaii. You went to Punahou. There's another famous graduate of Punahou in government as well. And you have a fine background in law. I think you went to Cornell, is that right?
Yeah, Cornell.
Eventually you returned to Hawaii after doing some corporate law on the mainland.
Right.
So you do know Hawaii issues and so forth. So in our state, you know, our politicians, our government institutions, do they need to be watched?
You know, all of these laws, the Sunshine Law or Public Records Law, they all originated back during the Nixon era. I mean, that's when they got really robust. You know, there have been pushes over the years, and it's hard to say that there are any agencies that are dishonest. You know, I'd never say that any are dishonest, but there are some that they either don't want to embarrass people, or that, you know, they're concerned about releasing certain information may jeopardize what they're doing, and so they're careful with what they release.
Sure.
And that's not always consistent with the public accountability role.
Well, we're going to take a short break now, but when we come back, I'd like to ask you for some examples of how government didn't provide the information it was supposed to provide, and you helped some people go after it. My guest today is Brian Black, the Executive Director of the Civil Beat Law Center. We're talking about keeping government open and transparent by going after the records that they deserve to give to the public. I'm Keli'i Akina, and we'll be right back after this short message. Don't go away.
Aloha, I'm Hunter Hevlin, host of Sustainable Hawaii here at ThinkTech Hawaii. You can tune in every week on Thursday at 2 p.m. to see interviews with sustainability professionals from around the state and even further abroad, learning about activities with water management, food security, waste management, and a whole host of other fascinating opportunities to get engaged with making a greener island. So if you're interested in making the transition from consuming individuals to communities of producers, check us out every Thursday. Aloha.
Aloha, my name is Miley Scarpino, and I'm the host of the Empower Hour. If you're interested in health, nutrition, fitness, here on the island of Oahu, want to learn more about places to train at or different trainers available, then watch my show on Fridays at 3. We have a great time, and I hope that you'll come join us. Much aloha. Now go get swole.
Welcome back to this week's edition of Ehana Kako on the ThinkTech Hawaii Broadcast Network. ThinkTech is broadcast across the world through live streaming and then on some cable channels, and our programs are sent out in various means. I want to tip my hat to Jay Fidel and all of the great staff and the crew at ThinkTech Hawaii. You can access their work at thinktechhawaii.com, and that's about 35 hours of original content produced here in Hawaii and sent across the planet. Today, we're talking with Executive Director Brian Black of the Civil Beat Law Center about the condition of records acquisition in Hawaii by the public and media, and what needs to be done to get the information we need to keep government accountable. Brian, isn't it the case that here in Hawaii we have some of the nation's finest sunshine laws and open records laws, and that if the laws simply could enforce themselves, this would be a pretty open, transparent place?
Yeah, no, we actually have very good laws. I think if you compare them to other jurisdictions, and in fact, it's very hard to do that type of comparison because each jurisdiction kind of has, it's like a fingerprint.
Sure.
None are alike. But you know, if you look at the impact of each one of them, I wouldn't say the impact. If you look at the actual language of each one of the bills, the language in our bill is, our laws is very good.
Well, that's comforting, but if that's the case, why do you have a job? Why is Grassroots Institute partnering with you so often as a watchdog and so forth? Obviously, there's some disconnect between these beautiful laws and their actual enforcement. And what's the condition of enforcement, and what are some of the reasons for low-level enforcement at times?
Yeah, so I think the legislature, when they passed the public records law, they were prescient because they said in their report when they were sending this law out, they said that a law is only as good as the people who are implementing it. And they challenged the government to take up that mandate that they were putting out there and to respect the spirit of the law and to make sure that records were more public.
So we have the very people who are supposed to be kept in check are the ones who administer the law. Is that what you're saying?
It is, but at the same time, I mean, there is a state agency, the Office of Information Practices, OIP. Yeah, so OIP does serve a role in terms of helping to interpret the laws and help requesters get information from agencies.
Sure. Now, you've been very helpful to many organizations, including the Grassroots Institute, and when we've had our people go down to the Office of Information Practices to tell them, please help us because this agency is not giving us the information by law they should give us.
Right.
We've often received responses such as, well, we get so many of these requests, it takes us up to a year to process them. We've got 4 requests that took 4 years to actually dispose of and so forth. Is the agency overworked or underfunded?
OIP is definitely underfunded for what it does, and they do have a significant backlog right now. And if you look, for example, at their annual reports, you'd see that their funding when they were originally created, they were funded for like 15 staff members. They're down to 8 full-time, I think. I'm not even sure they have that many. So there's a significant difference between when they were originally funded and they were handling a lot of requests, and now when they're struggling to sort of keep up.
Last year, a head of a department, a state department, a cabinet member actually came to one of our grassroots functions and on a panel explained something that helped to give further insight. And then that is that a great many of the records, and he said the vast majority of them, aren't digitized.
Right.
So you're either dealing with paper or you're dealing with scanned copies such as PDF files. So finding the data in the first place is a challenge, and that the computer systems in the various agencies and departments aren't all on the same system. So he was pointing out that by default, this makes it hard to get the records that people often have need of.
Yeah, that's true to some extent. I would say that, so there's a couple things I'd say is that, you know, if you compare it to the federal system also in terms of funding, the individual state agencies, they don't have people that are specially assigned just to handle requests. So they can't send someone off to go looking for documents and to do things. Someone has to take time from other work that they would otherwise be
Sure.
doing and look for stuff. And then on top of that, I would say, yes, it's true that there are many records that are not digitized, but even when records are digitized, sometimes you run into difficulties with the agencies. So.
Well, it sounds like there are many challenges, and so it's not sufficient to have laws that say we shall be open and transparent.
Right.
It's necessary to have the funding, the labor, the actual will to see that transparency does take place. And so you've been also involved in legislation. We'll talk about that a little bit, but first, before we go much further, tell us a story of one of probably your many experiences of trying to get information. I think at one point, you as the Civil Law Center wanted just the list of requests that are being made to different agencies.
Right, so and that interesting aspect of that is that it was a digital record, and so that ended up being one of the sticking points in terms of getting access. So what I was asking for was a list, a log of all the requests that each state agency had received for public records. And that would say a person requested a record, we either granted or denied it, it cost this much for the person to get that record. It was a log of just statistics about their record requests. And they were keeping them on Excel spreadsheets. And so I went around to each state agency and said, I want the Excel spreadsheet you had for the last fiscal year. And many agencies were very easy. They just sent it to me. But there were a few, and it depended on the particular agency, of course. But there were a few that that said, well, no, I don't want to give it to you. So then I would talk to them and get through that, to get through those issues. No, you have to give it to me. And then there were others that were there were a handful that tried to send me PDFs, which for what I was trying to do was completely useless, because I was trying to take all of the spreadsheet information and compile it and use it in different ways to be able to compare the information across departments.
Sure.
You can't do that with a PDF. And so, of course, one agency told me that I should just retype all the information into a blank template. I said, well, yeah, I could do that, but I don't have to under the law. You're supposed to give me the spreadsheet. So back and forth with a couple of those. I still have one agency I'm working on.
So have you been fairly successful in acquiring from the agencies the lists of requests that have gone to them for information?
After some initial pushback, which took, I'd say maybe half the state agencies up front just immediately gave it to me. And then the other, maybe half of the remainder, after about a month or two, they gave it to me after some back and forth.
Sure, after they talked to their bosses and lawyers.
Right. and then there was a handful that I was able to resolve within the last few months, and I've still got one outstanding. So most of them have actually.
And what do you intend to do with this information? I'm sure some were worried about what you might intend to do, but what?
But that shouldn't be their concern, right? I mean, it's what I do with the information. It's public.
You have the capacity now to check on the other side with all the people who've actually applied for information to see whether they got it or to see how they were serviced and so forth. So there's going to be some objective measure as to how well these agencies are doing in providing their information requests.
I could do that, although that would be...
You'd have a lot of work to do.
Yeah, that would be hundreds of requests.
We have some interns coming into Grassroots this summer. Maybe we should talk
have something
afterward.
to do, yeah. No, I was compiling the information in particular to try and figure out how much the government was waiving in fees for organizations who were acting in the public interest. And so there's a standard that allows for a waiver of a certain amount.
Right.
And with this information, I could figure out how much state agencies were essentially losing in money with respect to their waiving for public interest organizations.
Sure. Just a very practical question, and our viewers may not realize it, that people may have to pay for the information. But there are some stipulations in law that allow organizations such as news media, as well as public interest organizations, to have some kind of waiver. But what is the range? At the Grassroots Institute, we've done multiple dozens of these requests for information, and have not figured out what the scale for pay is. It's gone from nothing to $300 for 20 pages. How do they determine what the cost is?
So the rates are set at $10 an hour for searching,
Okay.
$20 an hour.
Now, when you search, does that mean you're online, you type search, or does that mean you go through boxes and boxes of files? Is there any discrimination there?
No, whenever someone is
just
looking for the
time.
file that you identified, it's however much time it spends them to find it. So if it was digitized and they're just searching in a file folder, on an electronic file folder, it could just be typing in, words.
Or it could be getting a U-Haul truck to go down to that warehouse and dig out that box of
It could
files.
be, yeah. But that's the cheaper rate. The more expensive rate is $20 an hour for any time that the agency has to review records and redact them. So that can end up
Redact
being,
means that's the black marker, right?
Yes.
Where
Yes.
they remove things.
Yeah.
Only a lawyer really knows whether or not they should remove. That's a very costly process, I would imagine.
Yeah, no, it is a difficult process for them to do it, and also for others to review it and figure out whether they want to challenge it.
Well, that's why rarely do we at Grassroots request all of the email correspondence of a government official.
Yes, no, that can be very expensive.
So, this legislative session saw many measures introduced, some passed, some failed,
Right.
many morphed in the process,
Right.
that had to do with helping to keep government more transparent. Did you have any favorites there?
I did. I had a favorite that I had hoped would make it further than it did, and that was SB 475.
Yes.
Which was a bill that would help folks get access to information through the internet, as opposed to, and this is for open meetings, so sunshine boards, help them get access to information through the internet, as opposed to postal mail or having to go to the agency or the board's office, things like that.
And that was so that people would have a quick access to information they needed.
Right.
Now, were you involved with the people who were introducing it?
That particular one it morphed to adopt language and ideas from other bills that I had been talking to folks about and getting introduced. So the original bill was focused solely on distribution lists for board meeting notices. And getting them on email, as opposed to having the notices go out by postal mail.
We'll come back and talk about some other examples of legislation that we've worked on this past term. But before we go, just really quickly, what grade might you give the legislature for their passing or failing to pass transparency legislation this past term? A tentative grade, open to appeal.
I suppose it's a C, because
Okay.
None of the pro-transparency bills passed. They were all bills that expanded on exemptions.
All right, when we come back from this short break, we're going to find out why our state legislature gets a C for transparency legislation this past term. And I think you'll be interested in some of the bills quite a bit. At least our public officials can rest easily that a bill that was said to result in physical harm potentially to our lawmakers did not pass. But in any case, this is Keli'i Akina with Brian Black. We're talking about government transparency. We'll be back right after this message.
Hi, I'm Jay Fidel. I'm host of Hawaii, the State of Clean Energy, which is our flagship show, which plays 4 to 5 p.m. every Wednesday. And the supporters of that show are Hawaii Energy Policy Forum and Hawaii Energy. And luckily enough, we have representatives of both of them right here today to tell you more about what they think about the show. Sharon Moriwaki at my left is co-chair of Hawaii Energy Policy Forum, and she goes first. Sharon?
Thank you. Thank you, Jay. I'm so glad that we have this Hawaii, the State of Clean Energy. This was 2 years ago when we started this, and we have continued it because it's so important, and there's so many developments happening across the state. We hope you'll tune in every Wednesday, 4 to 5. It's wonderful.
And Ray is Hawaii Energy. Ray, what is your thought about the same subject?
Well, I agree completely with Sharon that we are talking about every Wednesday, 4 to 5. We talk about some of the most important subjects that are affecting the islands, now and into the future. Energy, clean energy, we need it. We often run into new ideas that we had not thought about before. We did just today, and I think we're going to have more of that in the future. So come on down and watch us 4 to 5 on Wednesdays, and we'll see what happens.
We'll see you then. Aloha.
Aloha.
Aloha, and welcome back to our final segment of today's edition of Ehana Kako. Ehana Kako, what does that mean? Well, it's based upon a venerable Hawaiian saying, e pule kako. Even people at Punahou know what that means. Let us pray together. At the Grassroots Institute, we like to say, Ehana Kako. Let us work together. Let's work together for a better government, better society, better economy. And Civil Beat Law Center is one of the partners here in this state of people who are working toward those ends, and we're very pleased with that. I'm with Brian Black, Executive Director of the Civil Beat Law Center, that is serving the public by helping organizations, journalists, and individuals go after information that the public deserves to get from the government. And he does so by providing skill and knowledge and hard work. Brian, I appreciate all that you do. And I do want to say thank you for your work with many organizations, including Grassroots Institute. Now, this past legislative session, we were rooting for certain bills to pass, and some bills were a little bit hard to understand.
Yeah.
The one in particular was House Bill 287. You want to tell us a little bit about that?
It's such an interesting bill. It was originally introduced by the judiciary, and they were reacting. They introduced several bills this session, reacting to the idea that OIP had said that their birth dates, the judges' birth dates, had to be made public.
So they had a fairly narrow interest from the front end, and that was to protect some personal information of judges, particularly their birth dates, which factor into retirement dates possibly, or other kinds of issues?
Yeah, typically OIP will say that no government employees' birth dates shall be made public. What's different about judges is the fact that under the Constitution, the state Constitution, they have to retire at 70.
Okay.
In order to have accountability for that.
That's right.
You have to know what their date.
That would be something if there was a law that said they had to retire by a certain date, but nobody knew what their birthday was.
Right.
So, okay, it was a fairly narrow need.
Right.
But what got introduced was a fairly ambitious piece of legislation that touched upon a lot more than keeping out of the public, protecting the birth dates of judges.
Yeah, so there were 3 bills, and they ranged in what they went after. And so the broadest bill was the one that actually started moving forward. And that one was HB 287, and it was modeled on a federal standard for keeping information confidential in the context of record storage.
All right.
It was not modeled on the federal standard for public records disclosures. And so because of that, it had a really broad reach, because the idea is that if you're keeping records confidential, and there's much broader reach in terms of what you want to keep confidential, but if you have to disclose it under the law, you have to disclose it.
Right.
And so it was drafted with this standard of if it causes embarrassment, or if it would somehow be deemed unfair by someone. So it's this really broad exemption that they were trying to propose that is contrary, for example, to when President Obama came into office. He issued this memorandum that said, you cannot keep things private just because it might embarrass a public official.
Well, in fact, if that's an excuse not to make information known that this might embarrass me, or this might in some way show that I've broken the law, then isn't that the reason we're looking for that information in the first place?
It is. I mean, I don't think anyone's out to embarrass someone, but it is. I mean, accountability can lead to embarrassment, and someone might consider it unfair. It undermines the entire purpose of the law.
So this bill was written so broadly that it would prevent people from getting public records if passed.
Right.
Getting those records would result in some kind of embarrassment to public officials.
Right.
Now, didn't somebody see that at the front end and how ridiculous that sounds?
Thankfully,
And how
yes.
embarrassing. Oh, good.
Yes. Yeah. The first committee that it hit was the House Judiciary, and so the chair of that committee is Representative Rhodes.
Yes, Carl Rhodes.
And he saw it and questioned the judiciary about it. And when it left that committee, it was severely pared down, such that it was no longer an exemption, an outright exemption. It was moved into the privacy interest,
All right.
which means that it gets balanced against the public interest. And they got rid of the language about embarrassment, unfairness, and it was limited to only things that would cause a risk of substantial physical harm to an individual.
Okay.
It was like completely different.
So they had you in mind, that Brian Black would come calling with his big club.
Yeah, I guess so. I mean, they thought that that the idea was that if it could be used, what happened, I think, was that OIP had testified in that committee hearing and explained that there had been some instances in which information had gotten out, and OIP had said it must be made public when there might have been a stalker involved, or there might have been someone.
Right.
So this would add an additional interest that could be considered when you have those types of situations, so that stalkers or people who are out to cause potential harm, unless there is some extreme public interest, then that information would not come out.
What ultimately happened with that bill?
That bill that bill in that modified form, that severely reduced form, did pass, and I think it's pending before the governor.
Well, that's good news.
Yeah.
Now, there have been some attempts in the last couple of legislatures, at least, and prior to that, where agencies have attempted to evade scrutiny by having laws passed that would shield them from the Sunshine Law. Do you have some examples of that?
Yeah, although it's not a bad example. Another one that passed this session was Senate Bill 1208. And that bill allowed for the employees' retirement system to have a special exception under the Sunshine Law. So their board of trustees meets and they decide things like what the trust is, or what the board is going to invest in, what the fund is going to invest in. And the problem was that under the existing laws, there's nothing that would allow them to consider proprietary information in those discussions when they're having an open meeting. And so they technically could not have a conversation about investing in very special funds where those funds are saying, hey, we've got this great system where we can make awesome returns for you, but we can't share our formulas, our returns. We can't share this information with you unless you can keep it confidential. So if the ERS was in a position where they couldn't handle those types of funds, then they would lose out on good investments. So there was a bill that allowed for, and is now pending before the governor, that would allow for a exception solely for ERS to consider this type of proprietary information when they're doing their investments.
Now, that's a very specific bill.
Yeah.
It's a useful bill in that it prevents the kind of exposure of information that could actually destroy a deal or result in speculation or result in violation of some federal investment statutes and so forth.
Right.
Yet, the question that I want to raise is, how do we make sure that we only have those kinds of narrow exceptions as opposed to that mechanism being used to shield from the public things that they deserve to know?
And there, I think it's just a matter of diligence, right? It's a matter of watching the legislature when bills are going through, and it's a matter of watching the boards. Because the boards typically do, if there are boards that folks are interested in, the boards typically do discuss their legislative agendas and what it is that they're trying to do. And if you follow the boards, you can follow what it is they're seeking in terms of exceptions from the Sunshine Law.
So the public should be as involved as they can be as well when these kinds of bills are being processed and so forth.
Yes.
You know, you went to many, I'm sure, many hearings this past year, or do you go down there to the hearings?
I do, yeah.
And so forth. This is tangential to what we're talking about, but it's, in a broader sense, part of openness. Sometimes hearings are a little unwieldy. If it's a popular event and there are advocates on one side or the other, whether it's the rail surcharge of the GE tax and so
Right.
forth, you can have the room overflowing,
Right.
and long lines and hours, literally hours of people giving testimony one after another.
Right.
Do you think the hearing process itself is ideal for deciding the kinds of issues that we've been talking about? Or do these decisions tend to get made outside of the public hearing process? This is a sunshine question.
Yeah, I mean, as with any government process, and what I'll say is that, just to be clear, the legislature is not governed by our sunshine law. They're governed by their own rules, and so the same things that you would expect for if you were looking at the text of the sunshine law, that doesn't necessarily happen for the legislature. But I would say that there is a lot that goes on behind the scenes as far as legislation. But I don't think that if it were just the hearings, I think it would be too difficult for anything to be really discussed. There are sometimes when the issues are very complex and they require a back and forth that can't necessarily happen in a timely manner when you've got a hearing about 10 different bills. You can't discuss them all in that fashion publicly, not because of what's being said, but because everybody's there for different reasons, and you're going to have hundreds of people around for 10 different bills.
Certainly.
But so it does make sense that some things are happening behind the scenes. I think what's important is that the legislature be open about why it is they're doing different things. And I think, depending on the committee chairs and everything, a lot of them are very open about, we're making these changes because.
Yes. Well, you mentioned earlier that we do have good sunshine laws, good open records laws in general here in the state of Hawaii, but for various reasons, they're not always enforced. Funding of an organization, capacity of the Office of Information Practice, that slows it down a little bit, technological reasons and so
Right.
forth. What recommendations might you make to the state as we look toward the future? What would improve our capacity to provide transparent government?
I think there's a couple of things that, one in particular is that again, coming back to this idea that, the legislature is saying that this is really all about tone and attitude, right? Mm-hmm. I think the agencies, and this has to be something that's set from the top down. They have to adopt more of an attitude of this information must be made public. Except maybe there's some stuff that I have to hold back or that I need to hold back for some reason. I think now I don't want to give this, for some agencies, not all, but for some agencies, I don't want to give this information out. How can I keep it confidential? They're looking for excuses to keep things confidential, as opposed to an attitude of saying, I want to make this stuff public, but there are certain things that I need to keep confidential. So I think the attitude change is one thing. I think another one is looking more toward the media and the public interest organizations as a proxy for larger segments of the population, such that we should not be charging them thousands and thousands of dollars when they're making requests, because really those requests are being made on behalf of a large segment of the community, and getting that information out there is more important than how much it costs for someone's labor in order to put it together.
Well, those are two important areas: the attitudes of the organization, of the government organizations and agencies themselves, and the ability to represent the public through proxy organizations, watchdog groups.
Right.
Let's go back to the first of these.
Sure.
Do we have anything resembling sensitivity training going on in our public agencies or for our politicians and so forth? I know that there are many interests that somehow get some level of training out there that is mandated across the board for everybody to go through. Right. Does such a thing exist for transparency and making information available to the public so that we can somehow affect the culture of government agencies or attitudes of politicians?
I think part of the problem is that there's, as I was saying earlier, there's no set person necessarily at each agency
Right.
who's handling these things. So there's not a consistent body of people to educate. So one thing that a group of organizations has done is ask the governor, and I can't remember how many organizations, but over 20, got together and asked the governor to sort of issue a proclamation or an executive order, or whatever he's comfortable with, something to set that tone, to say that information, the presumption should be that information is open.
That's right. In fact, this is a good item to end on today. It shows what you at Civil Beat Law Center have been doing, and you actually were quite involved in that letter. Several months ago, you invited other organizations that serve as watchdogs for the public to sign on board with a letter that you developed,
Right.
to address our state governor, to ask him to be committed to these values of transparency and so forth. And how many organizations signed on?
It was over 20. It was, a lot of media organizations, Common Cause, the League, Grassroots. It was a large effort.
And you had an opportunity as a result of this to actually sit down with the governor.
Yes, I sat down with his. Had several meetings at this point. I sat down with his chief of staff. I've sat down with the governor himself, and I've also sat down with the attorney general.
And what is the reaction to the letter, basically?
They have all been very receptive. I mean, they're very receptive to the ideas. I think it's a matter of trying to figure out if there is something that they can do consistent with their goals.
What do you think the impact of government leaders, like our governor, of knowing that there are these multiple groups in the media and in public service that are, or in the public interest, that are coming together and saying, we want this standard of transparency?
I would hope that it has an impact. I hope that it shows them that this is really something that folks are interested in, and that they're willing to step forward and say this is important to us.
Well, and I thank you for your organization of that, your activism in it, and thanks for being on our program today, Brian.
Thanks for having me, Keli'i.
Aloha. My guest today is Brian Black, Executive Director of the Civil Beat Law Center, and you can get a hold of him at what website?
It's civilbeatlawcenter, all one word, .org.
civilbeatlawcenter.org. And do so if you or your organization are interested in help in getting government records. And I don't know if this means you're getting a flurry of calls, but appreciate the hard work of Civil Beat Law Center. I'm Keli'i Akina with the Grassroots Institute. Until next time on Ehana Kako on the ThinkTech Hawaii Broadcast Network, aloha.